Tonight's presentation, FAA is here to help. Our presenter, Mike Bush. Mike is president of Savvy Aviation Incorporated, an author for numerous aviation publications, a certified flight instructor, A&P mechanic with IA, 2008 FAA's Aviation Maintenance Technician of the Year, and a member of EAA. Mike, thank you very much for being with us tonight. I'm going to turn control of the presentation over to you.
Okay, well, good evening, Tim, and good evening, everybody. So the FAA is here to help, question mark. This tonight's presentation is a little bit unusual. It's actually a follow-up to a webinar that I gave 2 months ago in May. Some of you may have participated in it, and some of you may not have, but it was a story about a Bonanza owner, unfortunate Bonanza owner who put his airplane into a shop for an annual inspection, and he then got crosswise with the shop manager over something. I'll refresh your recollection if you weren't a participant in the May webinar. But at any rate, net result was that his airplane got thrown out of the shop in pieces. There were like 8 cartons of parts in the back of the airplane, and the manager of the shop basically told him not to darken his doorway again, and he was stuck with an airplane that was in pieces. And ultimately, he wound up calling the FSDO and getting involved with a airworthiness safety inspector at the FSDO, who was actually pretty compassionate about his situation and wound up helping him find a mechanic to get the airplane back into ferryable condition and ferried it to another airport with another shop where he got his annual inspection completed successfully. So shortly after my May webinar on this subject, I received a long and thoughtful email from a gentleman who I will call Fred, not his actual name. Fred was retired from the FAA after 2 decades of working both as an airworthiness safety inspector at a FSDO and also at an FAA regional office. He was a maintenance guy and had spent 20 years roughly working for the FAA, now retired. I called him Fred because I thought Fred the Fed had a nice ring to it, but that wasn't his actual name. But we'll call him Fred for the purposes of this webinar. At any rate, Fred was very concerned after listening to my May webinar that I might have given the wrong impression about when it is and isn't appropriate for an aircraft owner to ask a FSDO for help, and precisely what FAA personnel are and are not allowed to do. And so Fred and I exchanged a number of long emails on the subject. And I thought that a lot of what Fred told me was too good not to share, and hence this webinar. So I will quote some of Fred's words of wisdom, quite a few of Fred's words of wisdom in this webinar, interspersed with a few of my own thoughts. So if you see something on a slide that's got quotation marks around it, it probably came from Fred. And if you see stuff that doesn't have quotation marks around it, it's coming from me. At any rate, we'll start off. It says, Mike, I have to point out some things concerning your account of the compassionate Fed that I talked about in the case of the poor Bonanza owner. And then Fred first addressed the fact that the that the FSDO inspector had come out to take a look at this Bonanza that was kicked out of the shop in pieces, and he came out equipped with a flashlight and mirror. And that concerned Fred because he says feds are not allowed to do maintenance. He said specifically, he said, my problem is that your story infers that it is appropriate for an FAA maintenance inspector to inspect a private aircraft at the request of its owner, and then make a determination of what further maintenance would allow it to be eligible for a ferry permit. Fred said, that could be construed as an FAA employee acting on behalf of an owner, which he's not allowed to do, and arguably performing a maintenance function, inspection, which is a maintenance function, which is also not something he's allowed to do. The maintenance is outside of the scope of the responsibility of an FAA employee. The inspection function you described, looking at the aircraft and determining what would need to be done to make it eligible to get a ferry permit, should have been accomplished by a qualified technician, typically an A&P mechanic, who should have been retained by the aircraft owner, and then presented the FAA with an application for a special flight permit. The FAA's inspector's job is not to inspect the aircraft, but to review the application and the A&P's logbook entry, and decide whether or not to approve a ferry permit. So he's saying the FAA inspector's job is to decide whether to approve a ferry permit, but the job of inspecting the aircraft to determine if it's safe to make the intended ferry flight is not the FAA inspector's job. It's normally the job of an A&P mechanic. And I agree 100%. We deal with tons of ferry permits in my business, and indeed the normal protocol is for the owner to engage an A&P mechanic to inspect the aircraft, and then to make a determination that it is in condition to make the proposed ferry flight safely, and to make a logbook entry stating that. Now, this is a very low bar. We're not asking the A&P to say that the aircraft is airworthy, because if it was airworthy, it wouldn't need a ferry permit. This is an admittedly unairworthy aircraft, and the only real issue is the owner wants to ferry it to another airport, and the only question is the aircraft safe to make that flight? Is it safe to fly one more flight for 15 or 20 minutes, whatever the proposed ferry flight is? And so the normal procedure is to ask an A&P mechanic to look over the aircraft. This is usually a fairly rudimentary look-see. It's not anything like an annual inspection, and satisfy himself that the airplane is safe to make one more flight, this proposed ferry flight for which the ferry permit is being applied for. So the bar is very low, and it's usually very easy to get an A&P to do that. It's pretty unusual for an FAA inspector to come out and look at the aircraft and make this determination, although indeed the inspector does have the discretion to do that if he wants to. If he gets a ferry permit application and a safe to fly logbook entry, and he has any misgivings about whether or not the aircraft is safe to make the ferry flight, he certainly has the discretion and the authority to go out and take a look at the airplane for himself. But it's very rare for an FAA inspector to do that. Normally that's done by an A&P, and the A&P makes a safe to fly logbook entry, and the FSDO inspector accepts that logbook entry on face value and doesn't need to go look at the airplane. But he can if he wants to. It's just quite unusual. It certainly would be improper for the FAA inspector to do this at the request, at the behest of an aircraft owner. He's not supposed to do it because an aircraft owner asked him to. He's only allowed to do it if he feels that it's necessary to do. Now, in this particular case of the Bonanza owner, I honestly don't think the Bonanza owner asked the airworthiness safety inspector to come look at his airplane. He actually, his purpose in contacting the FSDO originally was to file a complaint against the shop because he felt that he'd been badly mistreated by the shop and wanted to complain to the FAA about that. Now, it turns out that that's really not an appropriate kind of complaint to make, and the FSDO inspector essentially talked him out of making the complaint and said, let's figure out how you can get your airplane ferried somewhere else so that you can get the annual inspection completed and get the airplane back in the air. So the FSDO inspector was quite helpful, but the Bonanza owner really didn't call the FSDO to ask him to help get a ferry permit. He called to make a complaint against the shop, and it was the FSDO inspector's idea to say, hey, let's not do that. Let's focus on getting a ferry permit for you and getting your airplane somewhere where you can get the annual inspection completed. So going back to Fred's email, he said, in follow-up to a complaint or an investigation, an inspector can physically inspect the an aircraft and its records, but only on behalf of the government to determine its compliance status, not on behalf of the aircraft owner. And I agree with that, and I don't think that's really what happened in this particular case. But Fred was worried that there was an implication that the aircraft owner asked the inspector to come out and look at the airplane, and the inspector did that, and that wouldn't have been proper, but I don't think that's what actually happened. It may be proper for the FAA to investigate a situation where one party claims a condition is unairworthy while another party disagrees, and indeed that was the case here. Ironically, the aircraft owner believed his camshaft in this case was airworthy. The IA who did the annual inspection agreed that it was airworthy, but the shop owner or the shop manager, who himself was not an A&P, had decided that the engine needed to be torn down, and the owner didn't want to do that, and so the shop manager wound up throwing the airplane out of his shop in pieces. But the investigation, again, Fred's words, the investigation must be fair and completely impartial, and an inspector cannot perform favors for private parties. It seems perfectly reasonable. The inspectors are not authorized to perform actual maintenance as part of their regulatory duties. In fact, they could lose their job for doing so. Now, in this particular situation, I don't. The issue hinged on the airworthiness of the aircraft's camshaft. The owner believed that it was airworthy. The IA who did the annual inspection agreed that it was airworthy. My staff viewed a bunch of high-resolution photographs of the camshaft. We agreed the cab was airworthy, but the non-A&P shop manager was convinced that the engine needed to be torn down. And when the aircraft owner wasn't willing to do that, the manager threw the airplane out of the shop in pieces. So given the sharp difference of opinion between the shop manager, who is not a mechanic, And the ANPIA who worked for him, who was a mechanic, and the ANPIA agreed that the cam was airworthy. The shop manager, for some reason, decided it wasn't airworthy. It does seem perfectly appropriate that the FAA inspector would come out and take a look for himself before deciding whether or not to approve a ferry permit. And in fact, the FAA inspector agreed with the owner, the IA, us, that the cam was airworthy, and that he disagreed with the shop owners who felt that it wasn't. Now the shop that threw the Bonanza out in the middle of an annual in pieces was the only shop on the field. The IA who worked for that shop, although he believed that the camshaft was airworthy, was not in a position to get crosswise with his boss, so he wasn't about to make a safe to ferry logbook entry. The owner made multiple attempts. We helped him to talk to A&Ps from a bunch of nearby airports to help him secure a ferry permit. And a bunch of them said that they would be willing to do that, but then once they talked to the shop owner, they backed off and decided that they weren't willing to get crosswise with him. This shop owner's reputation obviously preceded him. He was just a kind of a major troublemaker. The FAA inspector clearly didn't believe that he was committing maintenance on the Bonanza just by looking at the cam, since he didn't make any logbook entries or sign any logbook entries, which he would have been required to do if he was actually doing maintenance. So I'm sure that the FAA inspector did not consider that what he was doing by taking a look at the camshaft himself was performing a maintenance function, but rather just trying to satisfy himself who to believe with regard to his decision as to whether to issue a ferry permit. Which brings us to an important subject, which is that feds can't get involved in anything that looks like a business dispute. Again, going back to Fred's email, he said the situation you described concerning the maintenance shop appears to be a business dispute and not a regulatory or safety related problem. The FAA does not referee or resolve business disputes. There is no FAA regulation. This is kind of interesting. There is no FAA regulation that requires a shop or a technician to complete an annual inspection, nor to reassemble an aircraft that they've taken apart. That's a little scary, but it's true. By taking this airplane apart and then throwing it out of the shop in pieces, that may have been a despicable act, but it didn't violate any FAA regulation. There's no regulation that requires that a shop put your airplane back together once they've taken it apart. In my experience, it's very common for aircraft owners to complain to the FAA about mistreatment by a maintenance shop, where the mistreatment is essentially a business dispute and it's not a violation of any FAR or something that involves a threat to safety. Those are really the only two things that the FAA would be allowed to get involved with, either a regulatory violation or a threat to safety. And in this case, neither of those things took place. From an FAA's standpoint, throwing the airplane out of the shop in pieces in the middle of an annual inspection was a business dispute. It wasn't anything that the FAA could get involved in. And I always try to discourage owners from complaining to the FAA when what they're complaining about is something that doesn't involve a regulatory violation and doesn't involve a threat to safety, and is just a mistreatment. But they don't always take my advice. Sometimes they complain to the FSDO, and the FSDO inspectors typically won't touch anything like that with a 10-foot pole. And rightly so. That's not within the scope of their authority. In the case of the Bonanza, the shop manager certainly had the authority to terminate the inspection prematurely and to eject the airplane from his private property to the shop. In doing that, his actions may well have damaged the aircraft owner financially, but that's a civil matter for the owner and the shop manager and their respective attorneys to resolve. This is not something that the FAA is going to adjudicate. Even if the owner was damaged by the actions of the shop manager, which he probably was, he arguably was, the amount of the damages, the amount of the financial damages in this case would probably not rise to the level where civil litigation would provide a viable remedy. Generally, if the damages are not, pretty close to six figures, it's very, very expensive to bring a lawsuit. The only exception to that would be if the owner could have gone to small claims court and claimed whatever the maximum small claims court damages, maybe $10,000 or whatever it is. It varies from state to state. But if you're going to hire an attorney and get involved in civil litigation, it's very expensive, and it typically takes a long time. And so unless the damages were very much larger than they were in this case, that probably did not represent a viable remedy for the aircraft owner. But in any case, this is definitely not something that the FAA is going to get involved in. They don't get involved in anything that even remotely smells like a business dispute. Going back to Fred's email, sometimes the FSDO supervisor might allow an inspector to attempt a peaceful resolution, but never to use the authority of the government to resolve a business dispute. And to be honest, this would be a very rare situation indeed. In the 50 years that I've been involved in this sort of thing, I have never seen a FSDO inspector get involved trying to resolve a peaceful resolution of a business dispute. They just don't. They just don't get involved. Again, Fred's email. What the shop did might have been a breach of contract, although I'm not sure that there was anything more than an oral contract there. But it's not an FAA matter. There was no allegation that the shop or its employees were in non-compliance with any regulation. So it's just not an FAA matter. One more thing that Fred brought up, which is something I hadn't really thought of, but it's kind of interesting, is that the feds might not have even had jurisdiction here. The shop was not represented to be a repair station, a Part 145 repair station, and the manager is not required to hold a mechanic certificate. So the only the person performing the actual maintenance or inspection, in this case the IA, who worked for the shop manager and was actually a good guy in this scenario, is accountable to the FAA. The shop manager himself didn't perform the inspection and wasn't a mechanic, and would not have been accountable to the FAA. And the shop was not a repair station, so the shop did not hold any kind of FAA certificate. So the shop is not accountable to the FAA. Had the shop been a Part 145 repair station, then the situation might have been a little bit different. But even in the case of a 145 repair station, if the dispute looks like a business dispute as opposed to any kind of a regulatory thing, the FAA is not going to get involved. Again, Fred's saying if the shop or its owner, neither of whom are FAA certificate holders, decides to end the inspection or stop work, that decision is beyond the scope of FAA responsibility. Period. It's out of FAA jurisdiction, because basically the FAA really only has jurisdiction over people or companies who are certificate holders. Generally, only certificate holders are within the scope of FAA jurisdiction. And in this case, the bad guy shop manager didn't hold an FAA certificate, and the shop, which wasn't a repair station, didn't hold a certificate either. So the only people who could have possibly gotten in trouble with the FAA were the good guy A&PIA and the good guy aircraft owner. The bad guys were basically outside of the scope of FAA jurisdiction. So the bad guys were basically off limits. It's really important for aircraft owners to understand that there are two different kinds of maintenance shops in the world. There are Part 145 repair stations, and there are shops that aren't repair stations. As a general rule, most small GA shops are not repair stations. Big shops and ones that do a lot of work on turbines are more commonly repair stations. But if you're taking your airplane to a shop, it's a good idea to make sure that you know whether it's a repair station or not. A Part 145 repair station holds an FAA certificate, and so the shop itself, as a corporate entity, if you will, is accountable to the FAA. And Part 145 repair stations receive a lot more FAA oversight, have to jump through a lot more hoops, which has its pros and cons. The Part 145 repair stations tend to be more expensive because they've got a lot more overhead and they are regulated much more tightly, and they tend to be more inflexible. But on the other hand, if something goes wrong, the FAA might be able to help do something about it. By contrast, a non-repair station, which is what most small GA maintenance shops are, it does not hold an FAA certificate. It doesn't even exist as far as the FAA is concerned. From the FAA standpoint, it's just a collection of certificated mechanics flying in close formation. And in the case of a non-repair station, the shop itself is not accountable to the FAA. Only the individual mechanics who work for the shop are accountable in their individual capacities. If you have an annual signed off by a repair station, it's the repair station itself as a corporate entity that is signing off the annual. If you have an annual signed off by a non-repair station, it's some individual IA who works for that shop that is signing off your annual. So it's a different concept. So it's important for aircraft owners to distinguish what kind of shop that they're dealing with, whether it's a Part 145 repair station or whether it's a non-repair station. And one final thing to understand about feds, about our friendly FAA inspectors, is that they tend to be very risk averse. Again, going back to Fred's emails, and this is something I've noticed for many, many years. Another problem for the government involves liability if an employee, a government employee, makes a decision when working outside or even close to the limits of their authority and then something bad happens. Fred says that costs the taxpayers. The government has almost unlimited deep pockets when it comes to liability, and it gets sued a lot. And this apparently is something that's constantly on the mind of anybody that works for the FAA. I've long noticed that government employees seem to be a lot more risk averse than people who are in private industry, and I guess Fred's observation helps explain why that is. So at the conclusion of our long email dialogue, I said to Fred, I said the aviation safety inspector, the compassionate Fed, who became involved with the Bonanza, probably did go out on a limb. He may well have put his job at risk to help obtain a good outcome for the Bonanza owner, but that makes him a hero in my book. And Fred came back and said, I agree with your assessment. And I thought, Fred no longer works for the FAA, so I guess he's allowed to say that. But at any rate, there are compassionate Feds out there. But I thought that the dialogue that I had with Fred was very useful in explaining exactly what folks who work for the FAA are or are not allowed to do when it comes to helping aircraft owners. So Tim, that's all I have, but we can open it up for some questions or discussion.
Okay, Mike, let's start with Jake's question. He asks, who is responsible to ascertain that a shop is performing maintenance in accordance with the pertinent FAA quality standards, if not the FSDO?
Well, indeed, the FSDO does have oversight responsibility over maintenance people. In the real world, the FSDO performs regular oversight over Part 145 repair stations that are within that particular FSDO's jurisdiction. They come and make regular visits and they inspect paperwork and stuff. It's very rare for the FSDO to perform oversight over a non-repair station, which represents probably the majority of shops that work on piston GA. And it would be rare for the FSDO to perform oversight on a non-repair station unless somebody makes a complaint, which might trigger some oversight. So there's a very different level. But again, non-repair stations are not certificate holders. They're pretty much not on the FSDO's radar screen. The only people who are on the FSDO's radar screen are the individual mechanics and IAs, mostly the IAs, or many shops only have one IA. And I'm an IA, and I used to actually get to see a real live Fed once every 2 years when my IA came up for renewal. And that all stopped during COVID, and it's all done by remote control now. We don't even meet with the FSDO inspectors anymore, and it's now 2023, and it's still, the renewal this year was still the same thing. It was done by remote control. So I have a feeling that maybe that change is going to be permanent, and so it's quite possible for an IA to never see an FAA person, again, unless somebody makes a complaint against him.
Chris asks, in light of the FAA's inability to resolve shop aircraft owner disputes based on a safety issue, is there a way to enter into a contractual agreement with a shop that allows a third party to resolve the dispute without having to involve the FAA outside of obtaining a ferry permit?
Well, I mean, I suppose it would be possible, but uh, some, some shops uh, ask their customers to sign a written agreement before they'll work on their airplanes. A lot of shops don't. A lot of shops, the whole thing is done on, kind of on a handshake and a shoe shine basis. Um, it tends to be, very casual. And then there's another consideration which I've mentioned in other webinars, and that is um, most owners don't really investigate to find out whether the shop that's working on their airplane carries uh, liability insurance, errors and omissions, professional liability insurance. Um, and if the shop doesn't carry insurance and something bad happens, you probably don't really have very much recourse because the shop probably is pretty much judgment proof. Most shops don't have any significant assets. So one of the things that we always recommend that our clients do is ascertain whether the shop that they're planning on using carries decent insurance, um, so that if something goes wrong, there would be some recourse.
Jake wonders, for a non-145 shop, how do we know the person signing the annual entry in the logbook even has an FAA license?
Well, in theory, there's a regulation that says that the mechanic is supposed to make his license available for inspection. Again, most owners don't ask. They sort of take it for granted, but you're certainly well within your rights to ask. And there's actually a regulation that says that the mechanic needs to make his certificates available to you for inspection.
I wonder if the FAA's online database, anybody can search that. And
Yeah,
if you, I guess, knew the
that's
person's
absolutely true.
name.
Yeah, that's true. The certificate database, which is searchable by anybody, will show the mechanic certificate. It will show the inspection authorization. It will show the expiration date of the inspection authorization. So the mechanic certificates are like pilot certificates; they never expire. But inspection authorizations are only good for 2 years and have to be renewed every 2 years. And they're all renewed in odd numbered years at the end of March for some reason.
Must be in March when they required it to happen and they didn't think to stagger it
Yeah, I
over
mean
a year,
it
maybe.
is it is kind of nuts. It's CFI certificates are good for 2 years, but they all renew it at different times, so they're spread out over the years. But for some reason, IAs all get renewed at the same time, which used to be a huge burden on the FSDO, which may be why they've changed the procedure now, where it's all done online and you don't ever have to talk to the FSDO directly.
Hey, Paul wonders, does the FAA have to give a reason for denying a ferry permit?
Um, I don't. That's interesting. I would have to research the ASI's manual, which is a big, gigantic document online that calls out in great chapter and verse detail exactly what the FSDO inspectors are supposed to do in almost every conceivable situation.
Mm-hmm.
I don't know if they're required to give a reason. I would be very surprised if they would deny a ferry permit and not give a reason, because, you know, if they're denying the ferry permit, then they really ought to be telling you, what you have to do to that beyond what you have done to make the aircraft ferryable. For example, one of the basic rules about ferry permits, with very few exceptions, is that the FSDO can't grant a ferry permit on an aircraft that has an outstanding AD that's not complied with. And so one of the basic questions that they always have on a ferry permit application is whether all ADs are complied with. So if they denied the ferry permit because you didn't comply with a certain AD, then they really ought to tell you that so that you can go comply with the AD and then reapply for the ferry permit. So I would be very surprised if the FSDO was not, the inspector was not required to tell you why he was denying the ferry permit.
Paul's follow-up to that is he was told he has to go through the FAA's new online AWSC portal to apply for a flight permit. Wondering, do you know, is that true?
I don't, but it sounds plausible. That when you apply for a ferry permit, you're actually filling out a form that is an application for an airworthiness certificate. But in the case where you're applying for a ferry permit, you only have to fill out a few sections of this very long form, and you can leave the rest of it blank. And I know the FAA is trying to move as much of that stuff online as possible. So I think there's probably a pretty good likelihood that you're now required to fill that form out online. It certainly would be the most convenient way to do it anyway.
Chris asks, whose feet get held to the fire should a ferry permitted aircraft go down for mechanical reasons?
Oh, that's a really good question. I suppose that the A&P who signed the Safe to Fly logbook entry would certainly have a lot of splaining to do in a case like that.
And follow up from Chris, does a previously applied for ferry permit that was denied impact subsequent ferry permit applications? And does it matter if the A&P changes between applications?
I think the answer to both of those questions is no. I mean, it's obviously more work for the aircraft owner if they have to find a different A&P and get a new safe to ferry thing. But from the FAA standpoint, I don't think it makes any difference. And I can't ever remember us having a ferry permit denied, because you get your ducks lined up before you apply for it. And we all know, for example, that we need to research the ADs and be able to make a statement to the FAA that all ADs are complied with, because we know that they're going to ask that.
Okay, Michael asks then, so is the message here, don't expect the FAA to be able to help much, except in very limited circumstances?
Well, again, I think Fred was making it pretty clear that if there's either an allegation of a regulatory violation or an allegation of something that would arguably have impacted safety, then the FAA is going to be interested in it. And if it's anything else, then it's probably a waste of time to go to the FAA because it's outside of the scope of what they're allowed to do.
Hmm.
So those are really the two things. There's either got to be an allegation that some specific regulation was violated, or an allegation that, you know, the shop did something that could have killed you.
Right. Boy, good lesson tonight. Our final question here from Roger, he just wonders, what was the final outcome on the Bonanza issue?
Oh, well, we got a mechanic to come up and put the airplane back together in variable condition and it actually turned out to be the same shop that had done the prior annual on the airplane before this owner bought it, and the airplane was successfully ferried to that shop, and it got through its annual fine, and it's back in the air. So it had a happy ending, but it was on the ground for, I don't know, 3 or 4 months while all of this was going on. It wasn't very pleasant for the aircraft owner, and it was, you know, he was a new aircraft owner. This was the first annual on his watch, and it just blew up in his face in a most extraordinary way.
They're only going to get easier from here.
Yeah, that's right.
Let's see,
That's right.
the worst is over. Like a
Yep.
piece of cake from this point forward for him.
Yep, that's true.
Hey, Mike, take a moment and share closing thoughts with everybody here at the end.
Okay. Well, I hope we all had fun with Fred here. If you're not already on my email list to receive our monthly newsletter and interesting maintenance stories, easiest way to do that is to pull out your smartphone and text the word SAVVY, SAVVY, to 33777. That'll trigger a little mail bot that'll ask you for your name and email address and add you to our mailing list. Or if you stick around and complete the post-webinar survey that Tim's going to put up, I'm sure he would appreciate it if you would. There's a checkbox on that survey that if you check it, that'll also get you on the mailing list. My 4 books are still available at the EAA bookstore, at Aircraft Spruce and Specialty, and at Amazon. And the first 2 of the books are now also available in audiobook form on Audible. And as soon as I get back from AirVenture, we're going to start working on the audiobook version of Airplane Ownership Volume 1. So eventually we're going to get these all in audiobook format, but it's the last 3 books are 500-page plus each, so it's a big job. But anyway, that's a project for right after AirVenture to start working on the Airplane Ownership Volume 1 audiobook. And little plug for the podcast that I do with my colleagues, Colleen Sterling and Paul New, called Ask the A&Ps. It's a podcast that's produced by AOPA. It's available both as an audio podcast and also on YouTube as a video podcast. And it's a call-in show where we take calls from aircraft owners who pose their thorniest maintenance questions to us, and then we all argue about what the right answer is. try to solve the problems. We have a lot of fun doing it. So the podcast comes out on the 1st of each month. So the July podcast is now available, and we usually do the recording sessions about the middle of the month for the next month's podcast. So if you want to participate in the podcast and have a question that you'd like to pose to us, email it to podcasts@aopa.org, and our producer Ian Twombly will schedule you for one of the recording sessions, and we'll have a lot of fun together. So So that's the story about the podcast. And finally, the next 3 webinars that I'm going to be doing, they're normally first Wednesday of each month, except the August one's going to be the second Wednesday of each month, because the first Wednesday of each month I'll still be en route back from AirVenture. But the August podcast is titled Unbelievable Compression. We're going to be talking about what a horribly inaccurate and invalid test the compression test is, and what the reason for that is, and why we don't put a lot of weight on compression testing, and why we think a bore scope inspection is really the best way to determine cylinder condition. In September, the webinar is entitled Legal Interpretations, and talks about the fact that if you have a question about what a regulation means, you can write a letter to the FAA Office of Chief Counsel, and with luck, one of their regulatory lawyers will respond to you with a legal interpretation, which actually is a precedent-setting thing. And there have been a lot of very interesting legal interpretations that say that some of the FARs don't mean what they seem to mean. And so I'm going to go over some of those, and then go over a couple of requests for legal interpretations that haven't come back yet. And so we'll be talking about that. And then finally in October, I can't believe we're talking about October already.
It's going so fast.
Yeah, it's terrible.
Oh.
The webinar is entitled A Fortunate Catch. It's a story about an aircraft owner who had some cylinder work done, and before he took the airplane up for the first flight, he was looking over his engine and found something that caused him to not fly the airplane and to bring it back to the shop. And it was a lucky thing he did, because he probably would have had a catastrophic engine failure if he hadn't done that. So I'll tell you the story about that and some lessons learned from that. And that's about it, Tim, until next month after AirVenture.
Well, thank you
So
so much,
now we
Mike.
have to start praying to the weather gods, right?
Yes, yes. Hopefully we have good weather here in
I need you to
Oshkosh.
pray not only for the Oshkosh weather gods, but for the weather gods all the way from California to Oshkosh. Okay, can you do that for me?
I will. Yes, I
Okay,
will.
I appreciate that.
So, in other words, you're coming to Oshkosh, and you're going to be doing multiple forums during the week. If somebody would want to catch you live in person, um, tell us a little bit about what you got going on.
Well, I've got 11 sessions this year. Uh, Typically 2 or 3 every day, mostly on the Forums Plaza, except for one, which we're actually going to be doing a live version of the podcast at the AOPA pavilion that's near the flight line, but that's on Tuesday morning. All the rest of my presentations, which I'll be doing every day, Monday through Saturday, several presentations every day, are on Forums Plaza, mostly, not all, but mostly on Forum Stage 7, which is the big one in the middle, and covering a lot of different territory. I'm doing 4 of the presentations together with Colleen and Paul, and the other presentations I'm doing solo on a whole variety of subjects. But if you go to airventure.org and pull up the schedule, if you search on Mike Bush, you'll get them all. Or if you were on my mailing list, you got a newsletter a couple of weeks ago with my forum schedule. But it's all online.
Fantastic. Is there going to be any opportunity to have your book autographed, or I should say one of your books autograph during your venture? Is that an opportunity available to anybody?
You know, they actually haven't scheduled me in the whatever they call it, the author's corner this year. But if somebody has a book and grabs me after one of my 11 presentations, I'm always glad to autograph it. But no, we actually don't have a scheduled author's corner session this year. I don't know why, but.
All right, sir. Well, safe travels to Oshkosh. Thank you so much for all you're doing to help educate us. Great session tonight. Sure do appreciate it. And everybody who tuned in, thank you so much for joining us, and have a wonderful evening.
Thanks, everybody. Have a great air venture if you're coming, and we'll see you in August.